XRP has a comment window in Washington right now, and it shuts on October 20th. This is your XRP news desk. On August 21st, the Securities and Exchange Commission published a proposal called Regulation Crypto Assets, and sitting inside is a conditional safe harbor from the term investment contract. That term is the whole fight today. It always was. Before we're done, I'll tell you exactly what that safe harbor does, and I'll tell you the one thing the summary I read leaves unsettled, and I'll tell you why an options exchange is already using a completely different word for this asset than the SEC is. Like and subscribe if you'd rather have the file number than the headline. Plain version first, because the plain version is the one that's hard to find. The SEC has proposed the rulebook for crypto assets, and it has a front half and a back half. The front half creates a ways to sell crypto assets without registering it. One capped at 5 million across a 4-year period. One capped at 75 million in each 12-month period. Both of them carrying disclosure requirements, and the bigger one carrying financial statements and ongoing reporting on top of that. That's the offering half. So which half actually matters to a man who already holds this asset? The back half, every single time. The proposal includes a conditional safe harbor from the term investment contract inside the definition of security in the Securities Act of 1933 and in the Securities Exchange Act of 1934. Both acts, if the conditions are satisfied, the crypto asset is deemed not to be subject to an investment contract for the purposes of those definitions. Comments are due on or before October 20th. That date is doing more work than it looks like it's doing, so let me say it the second way. The proposal says comments should be received on or before October 20th, and it says every comment gets posted publicly on the Commission's own website under that file number. So the way that I take it, a window like this isn't a countdown to a decision. It's the stretch of time when the public record gets built out in the open, where anybody can go and see who argued what. I know what this room is feeling because I feel it too. We've been trained to hear the word proposal and reach straight for the mute button. Every docket was going to be the one. Meanwhile, XRP is at $1.41 right now, down around 5% in the last 24 hours. And that gap between the paperwork and the chart is exhausting. So I'm going to do the honest thing. I'm going to build the bear case on this rulebook as hard as I can build it. And if I can't beat it with the document, you shouldn't believe me on the other side. Here's the bear case in full strength. Let's start here. This thing is written for issuers. It's written for somebody standing up a new token and raising money. And the caps are $5 million and $75 million, which is nothing next to the trades in XRP on an ordinary day. Nobody is running a $75 million offering of XRP, so the front half of this proposal has nothing to do with you. Next, it's a proposal. Proposal rules die all the time, and October 20th is not an approval date, it's a comment deadline. And here's the sharp read. That safe harbor is conditional. The conditions are the entire ballgame, and the summary of that proposal does not tell you what those conditions are. So does any of that say XRP qualifies? No. It does not, unfortunately. And anybody telling you that XRP clears that safe harbor is guessing. That's the strongest version I can build, and most of it is simply true. Here's where I can break it. It breaks on the difference between a transaction and a definition. The offering exemptions are about transactions, about who sells what to whom and with what paperwork attached. The safe harbor isn't doing that job. The safe harbor reaches into the definition of the word security in the 1933 Act and in the 1934 Act. And it says that under stated conditions, this asset isn't caught by the phrase investment contract. That isn't a permission slip for a sale. That's a description of a thing. And an asset that already exists, that already trades, that nobody's currently offering to anybody else is exactly what a definitional carve-out can reach and a transactional exemption cannot. So who is that front door actually for? Builders, new tokens, new raisers, people who need a legal way to sell something they just made. And the back door, the definitional one, is for the asset itself. XRP never needed the front door. It has needed the back one from the entire beginning. Now the next piece of the bear case, the one that says proposed rules die. That's fair, and I'm not going to pretend that it isn't. Plenty of them do, but a proposal that's been published carries something a proposal that never got published does not. And it's this: the words exist now. They're printed, they're numbered, they're dated, and they're citable. And a lawyer arguing about what this asset is next year gets the point at a paragraph the commission wrote itself rather than a speech somebody gave. And I don't know if these particular rules survive. Nobody does. But the sentence about investment contracts is in the Federal Register, whether they survive or not. And that's a different world from the one where the definition only ever lived inside a courtroom. Now, let me bring the ledger into this, because there's something sitting on the XRP ledger right now that makes it concrete. Something very different shares those rails. There's XRP, there's RLUSD, where the issuer's account shows roughly $956 million in obligations outstanding today. Nearly $1 billion. Same ledger, same rails, and legally, they aren't the same animal at all. One of them is an obligation of an issuer who owes the holders something. The other one is nobody's obligation. So why would that difference matter to a rule about definitions? Because that's the exact distinction a conditional safe harbor has to be able to make. Conditions in this area get written about issuers, about promises, and about continuing efforts by somebody. The way that I read it, a ledger that carries both of those and keeps them legally distinct is a stronger position under a definitional rule than a weaker one. And here's the part I want you to sit with for a minute. 8 days before the SEC published that proposal, on August 13th, the Federal Register carried a filing from the Nasdaq ISE, which is an options exchange, proposing listing criteria for options on trusts that hold digital commodities. Digital commodities. Under the rule that already exists there, a trust like that qualifies when the total global supply of the underlying crypto asset has an average daily market value of at least 700 million over the last 12 months. And when that asset underlies a derivatives contract on a market that exchange shares surveillance with. 700 million, 12 months. And when that asset underlies a derivatives contract on a market the exchange shares surveillance with. 700 million, 12 months. A surveillance sharing agreement. Those are commodity words. That is a commodity test, and it's already written down. So hold both of those in your head at the same time. In one document, one regulator is proposing conditions that would carve out this asset for the word security. In another document, an exchange that same regulator supervises is already measuring the same asset class like a commodity with a dollar threshold and a surveillance agreement. Why would that be? My read is that the commodity plumbing got built first because it could be built without settling anything. And the definitional question, the hard one, is the one that's finally being written down. Now, let me ask you something, and I want the answer. A safe harbor whose conditions the summary I read doesn't spell out. Is that a win, or is that a stall wearing a win's clothes? Tell me in the comments, because I think this room is split on the one, and I'd like to see the split. Like and subscribe while you're down there. The line that moved me was the one about fraud. Under both of those exemptions, issuers stay subject to the anti-fraud and anti-manipulation provisions of the federal securities law. That's in summary of the proposal itself. So the SEC isn't walking away from enforcement here. It's keeping every power it actually uses against fraud, and it's putting down the one it used against ambiguity. And what has ambiguity cost this asset? Not the fraud rules, never the fraud rules. What costs holders was never knowing what word applies to the thing in their account. A regulator that keeps the fraud powers and writes the definition down in public is a regulator doing the thing this asset has needed all along. The paperwork isn't waiting on the comment window either. On August 25th, Granite Shares ETF Trust filed with the SEC and mentions XRP. On the 24th, Tidal Trust filed and it mentions XRP again. I'm not going to characterize what's inside either one, because what I've verified is that they exist and that they name XRP by name. The way that I read it, people don't file paperwork around an asset they expect to be defined out of existence. None of this is advice, and none of it is a price call. This is a desk reading documents out loud, and this week the documents were worth the time. So what actually changed today? Nothing on the chart, everything in the record. So here's where it lands. The rulebook that decides what XRP legally is now exists in writing with a file number on it. a public docket behind it, and a date at the end of it. And the way that I read it, that's new. Send this to one holder who convinced that nothing legal is moving for XRP. Don't forget to like and subscribe. Stack facts, not fear, and I'll see you in the next one.